Thanks for the Hypertension Society as well as Microlabs for picking up this topic and also inviting me to present my views on this. As my chairpersons as well as my fellow speaker Jagadeesh N has already pointed out, this is something new which has come in, and thus the legal impact is also something new for the medical community. So, in my next 15-20 minutes, we'll try to look at laws and regulations that cover social media use for doctors, and particularly this interface when we look at the medical community would be in terms of patient care. The other arena where we try to look at social media would be health education for patients and society. The third, which Chinappa brought out to a certain extent, is the professional life, wherein we try to have peer interactions through the social media and the personal life. So these are the four areas wherein there is an interface with the social media. We try to look one by one. The first is the patient care. Today, if you try to look out, I have put the dots at the end. These are just a minimal thing which I have picked up, which are more popular in the Indian context. If you take the global context, there's many more. Whether it's Practo, 24/7, Librate, 1mg, likewise, or these are specific to the medical community. Or if you look at the general things like the Facebook, LinkedIn, or Instagram, Twitter, Google Plus, or likewise. So many of these have entered into the medical profession, and we are now having an interface of the social media in our medical profession. The previous session was on the ethical aspect, but today something has become a norm wherein today searching a hospital or a doctor on these apps is something considered appropriate. Booking consultations for admissions or procedures in the hospital is something which is considered as a new normal. But are these a new normal? Is there a selective bias? Are these apps trying to pick a select a doctor or a select hospital? Or how are those? So, if something goes wrong, so whom should we sue? Is it only the doctor? Is it only the hospital? Or can the patient sue the app? So that's something new, the legal dimension which has come in. Another dimension, particularly the public image of a doctor, the online visibility of a doctor, and the issues which are proclaimed through health education or in terms of posts being posted by the doctors or the hospitals. So that's something, if it goes wrong, then all the stakeholders are liable. Additionally, the social media, the app is also liable. Feedback among the clients, that is the patients, about doctors. This is something which is happening today. There's an image being built about a hospital, about a doctor through the social media presence, the likes they get, the dislikes they get. So that's another legal domain of late which has added up. Promoting ease of access to pharmacy services or diagnostic services in the patient care. As I pointed out, apart from selecting a doctor or a hospital, if it is selecting a pharmacy or a diagnostic center, so something goes wrong, then the app would also be liable along with the concerned diagnostic lab or the pharmacy. This was shared by Jagadeesh N, but I want to go more in detail on this. This is a couple of years old case, but it's very pertinent for our discussion today, because today it's something which is so common. A doctor would click something which is unusual, click something which comes out, and we feel proud in trying to push it through the social media. But what happens if you don't follow the legal norms? Three docs were suspended for sharing the cesarean section photos via the WhatsApp. Though it was a rare case where they were delivering a triplet, but the essential point was without consent. If you read this paper news, it goes saying that immediately after the discharge from the hospital, The lady went directly to the police station and lodged a complaint. Immediately, the state medical council suspended the doctors, but it didn't end there. It went beyond that into a criminal complaint, and the paper post is trying to say that the High Court denied bail to the doctors because the cases which were put, the criminal cases which were put of indecent assault of 354 IPC. So that means the photos which were shared were the genital parts of the female, and without consent or with consent also you can't share that. The issue is the IT Act of 2000, particularly Section 66E, violating the privacy, which talks about capturing, publishing, transmitting image of a private area or part of the body. And again, sexually explicit material in the electronic form, 67A of the IT Act, were the charges which were framed. So the take-home message from this is you cannot post anything with it without the consent of the patient, and whatever we were doing in the past, that cannot become the norm. So we need to follow the ethical values as well as the legal thing, because now the privacy laws are very, very clear, saying that without consent we cannot do any of these acts. So an advertisement of a doctor, as I pointed out, the interface, what we are currently doing is we try to put ourselves into practice. I'm naming some of them, but it could be any of those apps, trying to make myself visible in one of those apps which are available in the market. Is it an advertisement? If I pay more, so I get a bold advertisement, I get a front homepage advertisement, or I may be made visible. So are these legal? Definitely not. So the Code of Medical Ethics very clearly bans advertisement in all contexts, but it gives a small window when you start or close your practice or shift your practice. Those are the only areas when it allows. But beyond that, if you try to make yourself available, so that would be violative of your Code of Medical Ethics as per the erstwhile MCI, which now would be automatically applicable under the NMC Act also. Putting self photographs so that our visibility is very clear. We had a case about the print media, but similar advertisements are running through in the social media, and trying to show the photographs of the doctors of a particular hospital, and trying to show would also be violative of the Code of Medical Ethics. Self-boasting of your capabilities. So many a time we put our profiles which are online, and we try to say that we did that surgery, we did this procedure, we have treated so many people. If any false claims are put in, so we need to be very cautious, because this online forum is a verifiable forum, and everything will have a digital trial, and all our false claims will be counterproductive against us. Posting previous patient cure details without consent would definitely be violating privacy and confidentiality. The previous newspaper report very clearly points to that. Soliciting patients online is against the Code of Medical Ethics. But what are these apps trying to do? What are these social media presence trying to do? So that's something which we have to be very careful. Whatever the regular human interface doesn't allow, the same is not allowed in the social media. We should be doubly careful when we are posting the child's photos, particularly the genital images. Automatically it comes under the child sexual abuse. Posting the patient photographs without consent, the previous case itself, how the IT Act of 2000 would apply. Spreading false information, this is something in the COVID era we have found, and there are cases which are being claimed under the Epidemic Disease Act as well as the Disaster Management Act. We have to be very careful what goes out from our handle, or Twitter handle, or WhatsApp, or how we are, even if it is hacked, we need to immediately lodge a complaint saying that your handle is hacked. Otherwise, whatever issues happen from your handle, you are liable until it is proved the converse. Posting or sharing patient reports. This is something which has become a new norm. All my subordinate or the resident doctors may send the patient details for a further advice. But have we sought the consent of the patient when we are posting this onto an online platform? Or these all WhatsApp or Telegram or whichever social media we are trying to use, sitting at the comfort of our house, if we are trying to without seeking the consent of the patient, and tomorrow anything which enters into the internet is out into the world. So are the firewalls is such strong enough that they can, when we are using a third party interface wherein we don't have a control over the app, in such situations definitely without consent we are liable. Today, we have telemedicine practice guidelines from March with the COVID, though these were pending from quite some time. The government, in the COVID initial days of March, they had to give out so that we have some amount of medical practice in the lockdown period. And look out, it says very clearly that there should be a patient assessment and an examination. Without that, there cannot be any sort of a medical management. And identifying the patient online is a must. And if I'm trying to go with a WhatsApp message, and if I have not seen the patient, if I have prescribed something and that goes wrong, then definitely I'm liable because it has gone through from my WhatsApp number or from my WhatsApp post. So identifying the patient is a must. The telemedicine practice guidelines clearly give out there could be a patient directly contacting the doctor, the caregiver would be a paramedic, and likewise, or the kith and kin of the patient who would be interacting with the doctor, the paramedic, nurse, or others who are interacting with the doctor, or another colleague trying to interact with the doctor. And in emergency, little later we come back how that is different. So if the patient is not identified and you try to give out your professional advice, then you may, if it goes wrong, you are liable. Today we are looking at prescriptions which are sent online. Very clearly, telemedicine practice guidelines put out. If you don't follow the list what is given out, then it's professional misconduct and an additional penalty. Over-the-counter medicines are put into list O, but whatever you are giving in the first consultation or for a refill, it should be only done through a video consultation, and that is all at the list A drugs. The follow-up consultations, what you prescribe, are put into the list B, but there is a strict no for all the drugs which come under the NDPS Act or the Schedule X. They are prohibited. So you cannot give them online. You cannot prescribe them through your social media or whatever be the internet interface. We need to be very careful. Jagdish N pointed out about the footballer, how the professional life got out. But the same thing applies even to the healthcare provider, whether it's a doctor, whether it's a nurse, whether it's a paramedic, whoever it is, whatever we speak on the social media, we should be very clear. We cannot argue out as it's a freedom of speech. Yes, we all have fundamental rights, but there are reasonable restrictions to that. If the comments what we put out are racist, whatever ethical principles we have, we cannot be religious, racist, caste, creed, color. So any of these, if we violate, definitely a defamation suit is definite on us, because we have a digital proof which is against us, which automatically proves that we have violated it. Another area where we have to be very clear is the conflict of interest, particularly the photographs which you post about your own professional life. What is visible behind you? If you are trying to promote a particular brand of a medicine or a particular device from a biomedical company, so tomorrow you would be charged for a biased approach. And if the claim which you are putting it is not correct, then definitely you would be having a legal suit against you. So the conflict of interest has to be proclaimed well in advance. The other issue, whatever we post online, we should be very careful. Whatever photographs I'm trying to take online, whether they are protected from copyright issues, whether there are licenses to procure, whether there are any patents to procure. Otherwise, definitely I'm liable under the Copyright Act, the Patents Act, as well as violating the license. I would be having a civil suit as well as a suit under the company law. And another aspect which we have to be very careful what we post in the social media, we may proclaim several claims, and if that is not originally your thought, or it's not originally your idea, if you don't do a proper acknowledging or a proper referencing of the original source, then all the laws of plagiarism would also apply against us in the social media. The breaches of patient privacy, we had enough examples in the previous session, and this session also. They are not only under the Code of Medical Ethics. The Puttaswamy case, the Supreme Court has very clearly brought out the privacy, the right to privacy. And today we are, when we are not sharing our own fingerprints for Aadhaar, or likewise we don't want Aadhaar to be made compulsory. So definitely what we do in the professional life, particularly when we are trying to look out the patient information, we have to be very careful, otherwise we are legally liable. We need to be very careful because now there is a new, Jagadeesh N brought out that there is an interface of the social media between the doctor and patient. Now there is a new norm for this doctor-patient relationship with an additional party of the social media in between. Any violation happening at any corner, whether it's by the social media or by the doctor in particular, so definitely there would be the breach of the doctor-patient relationship. We would be liable both ethically and legally for that. We need to be also very careful about what we post and what we comment on the social media, the follow-up comments, what we do, what we post. Yes, we also have a social life, but once you put your party images wherein what is not acceptable to the professional life, your images over there, that definitely would dent your professional image. And if you have chosen to post yourself, then definitely you are to be blamed. If somebody else posted, then definitely you have a defamation suit against those people. More and more apps are coming in. We are quickly embracing them without doing a check behind what it actually proclaims is true or not. There are many apps to run your OPD, which run your own hospital, nursing home. Likewise, we are even now going into the electronic medical records. Today, if there are no protective mechanisms, particularly firewalls and safety precautions, and the data of the first today's presentation from Dr. Devi Shetty was trying to show what's the new interface and how the things are changing thick and fast. And the doctors need to upgrade ourselves, and if we don't upgrade ourselves and whatever available in the market, we get into those apps, and tomorrow the patient data gets breached. The patient is not going to sue the app, patient is going to sue the doctor, and then you are to yourself defend for choosing or trying to take that app. The new norm is doctor-patient relationship established on physically a patient reaching the doctor clinic and getting examined? Yes, the answer is definitely yes. On sending an email, and if the doctor responds, the patient sends an email regarding whatever professional advice they want, and the doctor responds to that mail. Is the doctor-patient relationship established? Yes, definitely it's established. And tomorrow, in a hurry, I just typed the drugs, and things went wrong. So I did not personally examine these defenses, or alibis will not come. So we will be liable for medical negligence. So because the doctor-patient relationship would have been established the moment the doctor responded by answering the email. Similarly, on sending a WhatsApp message, if the doctor responds to that patient's WhatsApp message, giving the professional advice, then definitely a doctor-patient relationship established. Similarly, on sending a Facebook request and the doctor responds, and for the apart from the request, you also give an advice over there, or you try to give a response to that. For you may feel that it's not a professional advice, but the moment you put a response on the social media from you as a doctor, so the doctor-patient relationship establishes. Otherwise, you have to refrain yourself from putting your professional advice over there. Uh, this is something which came out from the US. The Facebook, Twitter, YouTube removed a video of the so-called doctors who are denouncing masks and promoting a particular drug. So immediately, this took a furore, and even the president of US had to respond to this. And all these social media apps removed that video because it was trying to proclaim something which did not have a scientific basis. And this is something which has happened. So whatever you put onto your social media, if you don't have a scientific backing, scientific evidence to back up that, then definitely you are liable for posting those false information. The poor quality of information or the wrong information shared on the social media, the poster is definitely responsible. So even the Disaster Management Act, the Epidemic Disease Act have enough check mechanisms for that. All the lab reports, whatever we are sharing, even the radiology reports, it should be only with consent. We had the famous case of teleradiology when people from US sued them, saying that we had never consented that our images should be shared with the Indian doctors. So if in fact your hospital is sharing to an outside doctor or an outside hospital, wherein you are seeking professional advice, which forms part of the patient care, it should be well within the information given while seeking consent with the patient. Nothing can happen with hide and seek. If anything happens with hide and seek, if something goes wrong, definitely patient has a right to sue. You can't argue that we sent on an anonymized data. Even an anonymized data, if there is a reference to any patient, then definitely the patient has a right to sue the doctor. Is accepting patient as friend acceptable in the doctor-patient relationship? Uh, we are also human beings. We are also part of the same society. We need to be also part of the social media, but definitely we need to have our own boundaries. The moment I, as a doctor, accept a patient as a friend, and subsequently, if that in that group the patient puts a status that he or she is not feeling well, and if a doctor reminds the patient to take medicines on that group, does that mean it violates privacy? Because your message is not only seen by the patient, it's seen by the entire group. So can the patient sue you? The same comment in the general fora may not attract any attention, but the comment by you as a doctor, unless until you have denounced yourself as your professional profile, so that's something which we have to be very careful. The legal issues which have a conflict between your personal profile and the professional profile. So we need to be very careful regarding the safeguards. We should be doubly sure who are part of your, what is part of your profile data, which you are sharing with as a part of the professional care, and your own social site, what you are looking as a personal profile. So who are the people whom you are going to interact? So if you don't maintain that safeguards, if there is an overlap between the two, definitely it's a murky area or getting into legal quandary. So not to respond to requests for therapeutic care on personal profile. So tomorrow you can't argue out it was a general message which was put out, and I as a general respondent gave it. There is no doctor-patient relationship. I did not agree to care for that person. So all those things will not be acceptable the moment you have not separated your personal profile with the professional profile. The patient privacy concerns in a personal profile. Though you are running a personal group of your own relatives, but amongst them, one of them is also you are seeking your professional advice as a patient. So whatever information you have through the professional channel, you cannot share that information in the personal group. Then definitely that patient can sue you for violating the boundaries, ethical boundaries, as well as the legal boundaries. Before we end, let's look into now the new norm in India. Thanks to COVID, we have a new interface. Now we are having the telemedicine guidelines, which are part of the same Code of Medical Ethics regulations under Section 3.8, which very clearly says mandatorily issuing of prescription. So there should be a prescription, there should be a digital trial, there should be a documentation of the consultation, the logs, records, charts, everything should be there. You can't argue that it was part of a social media response which you have given. Tomorrow there is a suit against you for by not maintaining this digital trial itself. You would be liable under the telemedicine practice guidelines. You definitely, yes, you can charge your fee, but the fee again comes with the same code of medical ethics regulation. You need to give a receipt, and that receipt automatically would be having a digital trial, and there's nothing of a hide and seek over there. In emergencies, you need to restrict yourselves to first aid. You can maximum advise about the referral where you can facilitate, or the counseling what can be for the initial period. Barring this, if you go beyond it in an emergency, it would not be applicable under the telemedicine guidelines. Unless until you have another doctor who is beside the patient and you are trying to advise that doctor to take care, then that doctor is primarily responsible. If you are directly interacting with the patient and then things go wrong, then definitely you are liable. It's not like the Bollywood movies where it's trying to portray. There is a strict no for surgery and invasive procedures through telemedicine. You cannot do that. The guidelines end up saying that ethics are the foremost, data privacy is the responsibility of the healthcare provider, maintaining confidentiality. It puts a strict no on advertisement. So all those apps which are in the market, recently we had a couple of legal suits against some of them. So we need to be very careful. One, yes, we need to make a professional practice, but the other, we should also have an ethical and a legal practice. What the law does not permit, I am afraid we have to strictly follow that. Otherwise, we would be liable for the charges of misconduct or penalty. Though the list puts out soliciting patients, privacy violation, all those acts which we do without consent. But the telemedicine guidelines are a couple of almost 70, 80 pages. The entire is almost 100 pages. So unless until each doctor goes through all those things and personally agrees to that, then definitely you have to be careful with the ethical and legal requirements of the usage of social media. So through this, we touch based. This is a new arena. This 20 minutes is too less to discuss the intricacies. Maybe we have just gone into a bird's eye view. We have several such case scenarios to discuss across the globe, because telemedicine was there part of the Western world quite earlier, and today we are just 7 8 months old. So we need to be very careful in picking up the laws. So thank you very much.